On May 14, 1969, Associate Justice Abe Fortas made history as the first Supreme Court justice to resign due to an ethics scandal.
Justice Abe Fortas resigned from the Supreme Court of the United States today.
He insisted he had done nothing wrong, and there was no public evidence he had violated any law.
He emphasizes that he's resigning to free the court from the public controversy surrounding it.
It turned out that Fortas had been receiving an ongoing retainer from somebody who might have business before the United States Supreme Court.
50 years later, it might seem like the Supreme Court is facing another Fortas-like scandal.
Pressure is growing on Supreme Court Justice Clarence Thomas over his ethical decisions.
An undisclosed relationship the justice maintained with a billionaire Republican donor named Harlan Crow.
Luxury vacations for a sitting Supreme Court justice.
Thomas does appear to have violated the law.
In his defense, the law is complicated, and he's only a Supreme Court justice.
This means we should be expecting another resignation, right? Not exactly. Like everything else in Washington these days, the response to Thomas's actions has fallen along partisan lines.
This is untenable. Ethics cannot simply be left to the discretion of the nation's highest court.
A concentrated effort by the left to delegitimize this court.
The Thomas allegations, along with reports of misconduct by other sitting justices, have done little to restore the public's already low opinion of the court. Did the framers intend for Supreme Court justices to be immune from oversight? Who, if anyone, can hold accountable the people who sit on the highest court in the land?
It was Alexander Hamilton in Federalist Number 78 who pointed out that the courts lack the power of the purse or the sword. Ultimately, they depend on the confidence of the people.
This is Erwin Chemerinsky. He's the dean of the UC Berkeley School of Law and a constitutional law scholar. He says the framers focused on protecting the courts from interference from the other two branches of government. Take Article 3. It's the part that establishes the federal court system. To ensure politicians don't meddle in the court's rulings, it explicitly states that judges' salaries can't be reduced, and that they hold their offices during good behavior. That is, for life. But what if a justice goes rogue?
Although appointment is for life, any justice can be removed by congressional impeachment.
It's only happened once. The year was 1804. Samuel Chase was a founding father. He even signed the Declaration of Independence, and he was a sitting justice on the Supreme Court. He was also a staunch Federalist, the party of Alexander Hamilton and John Adams, who had just been swept out of power by Thomas Jefferson's Republicans. It was the young country's first transfer of power between political parties, and there were a lot of questions.
It was unclear then as to whether or not, when there was a new political party, they should be able to remove all of the justices from the prior political party.
So when Jeffersonian Republicans gained control of Congress, the House voted to impeach Chase on purely party lines. But in the Senate, enough Republicans broke rank. Chase was acquitted. The precedent was set. Politicians couldn't just oust a judge because they disliked their rulings. Congress hasn't tried to impeach a sitting justice since. It took another 100 years until the 1920s when two events led to the creation of formal ethics rules for judges. The first involved a scandal that almost destroyed the integrity of America's national pastime.
It's 1919, and here are leading investigators in probe of recently finished World Series.
8 Chicago White Sox players were accused of throwing the World Series in exchange for money from a gambling syndicate.
In move to clean-up game, team owners in 1920 made Judge Kennesaw Mountain Landis High Commissioner of National Pastime.
The only problem? Landis was also an active federal judge. Which raised the question, could he be both? No ethics guide offered an answer. A public outcry forced Landis to make a choice. He eventually stepped down as a judge to become the first commissioner of Major League Baseball. One of his first acts, permanently banning all 8 players.
No player who throws a ball game will ever play professional baseball again.
Following the Landis saga, the American Bar Association came up with a code of ethics for judges. The rules weren't binding, but over the years, all 50 states adopted them in some form. The second thing to happen in the 1920s? Congress created the Judicial Conference. In addition to wearing fancy hats, the new agency gave courts more freedom to set their own administrative policy. It took another scandal nearly 50 years later for the conference to finally adopt the ABA's code. That scandal? Abe Fortas.
The United States Judicial Conference today issued a code of ethics which forbids all federal judges, except Supreme Court justices, from accepting fees, gifts, or compensation of any kind for off-bench activities.
Wait, what was that?
Except Supreme Court justices.
What makes the Supreme Court justices so special?
A spokesman for the conference, which is made up of 25 federal judges and headed by Chief Justice Earl Warren, said it has no authority to lay down rules for Supreme Court justices.
So to recap, the Judicial Conference, created by Congress in the 1920s, after the scandal with a Supreme Court justice, adopted a set of ethics rules to apply to all federal judges.
Except Supreme Court justices.
Today, Chief Justice Roberts is head of the Judicial Conference. He agrees. Roberts argues that because the Judicial Conference was created by Congress, it doesn't have the authority to impose rules on the High Court. Justice Alito went even further. Congress did not create the Supreme Court. No provision in the Constitution gives them the authority to regulate the Supreme Court, period. But like most Supreme Court rulings these days, even the justices themselves are split.
It just can't be that the court is the only institution that somehow is not subject to any checks and balances from anybody else.
Congress regulates the Supreme Court in all sorts of ways. It sets the number of Supreme Court justices. It sets the salary of the Supreme Court. It sets the budget of the Supreme Court. The question is, can Congress go even further and mandate an ethics code? And I think the answer to that is clearly yes.
But here's the thing. Even if Congress did impose an ethics code on the Supreme Court, guess who could eventually rule on its legality? Yep, the Supreme Court. At this point, you might be thinking, are there any laws the justices must follow? Well, yes. This one specifies when judges and justices must recuse themselves from a proceeding. And this one requires federal judges, including Supreme Court justices, to submit annual financial disclosures. That's the law Justice Thomas is alleged to have violated.
Legal scholars I've spoken to have said that this is something that could be referred to the Justice Department, that they could investigate and look into as to whether or not any criminal action or civil action could be taken against him. But I don't know if there's any political will or interest in actually doing that.
It's so important that the most important justices in the country have to follow the same ethical standards as all other judges in the country.